don't need any introduction. We all know who you are, so I'll go ahead and let you introduce Josh Blackman and we'll begin.
Thank you so much. I was given this little handout to read here.
It's very short.
Please join us in welcoming Professor. Professor
You have a bell
Josh.
system here? I've never seen that in law school.
And lockers. It's like high school and clicks.
I know.
It comes and goes.
It's like Mean Girls, right? We gotta.
All right. Please join us in welcoming Professor Josh Blackman, who has traveled to OU Law from Houston.
First time here
today. Josh Blackman is a tenured professor at the South Texas College of Law, where he has taught property, constitutional law, and First Amendment courses. Professor Blackman graduated with highest distinctions from Penn State University and earned his legal education from the George Mason University of Law. He is an adjunct scholar at the Cato Institute, as well as the founder and president of the Harlan Institute and founder of Fantasy SCOTUS. Professor Blackman's areas of expertise range from constitutional law, law and technology, and the U.S. Supreme Court. Professor Blackman has authored over 4 dozen law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, the Washington Post, USA Today, and various other national publications. Thanks for coming out. Appreciate it.
Thank you. Now I have power. Thank you so much. It's my first time at the University of Oklahoma. Never been here before. My friend Joseph Ty, I've been known for many years. Professor Tepker, I think we've done a few events before, so good to be here. The students asked me today to talk about free speech. No, not blackface, not fraternity stuff. a more relevant topic for attorneys. And this is ABA Model Rule 8.4G. In August of 2016, the ABA approved what's called Model Rule Professional Conduct 8.4G. Let me read you the text. Under this rule, it is misconduct for an attorney to engage in, quote, conduct that the lawyer knows or reasonably should know is harassment, discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. And comment 4 explains, quote, conduct related to the practice of law includes representing clients, interacting with witnesses, coworkers, court personnel, lawyers, and others while engaged in the practice of law, operating or managing a law firm or law practice, and participating in bar association, business, or social activities in connection with the practice of law. It's a mouthful. I won't read anymore, I promise. The model rule is just that, a model that does not apply in any jurisdiction. For the last couple of years, states have considered whether to adopt Rule 8.4G. By my count, 2 states have accepted it with some revisions, and the overwhelming majority of states have either rejected it or tabled it, which means reject it, we'll deal with it later at some other point. In 2017, I wrote an article in the Georgetown Journal of Legal Ethics, and I urged state courts to pause before accepting 8.4G. My concern isn't so much about the legal ethic component, but more about the First Amendment. And I filed comments in a number of states urging states to reject it. So here's my tentative scorecard, which changes every couple months. 6 states have formally rejected it: Arizona, Idaho, Montana, New Hampshire, South Carolina, and Tennessee. 3 states withdrew the petition: Nevada, Louisiana, Alaska. There are 3 states where the comment period has been open for like a couple of years with no decision: DC, New Mexico, and Utah. At least 2 states have open comment periods now: Iowa and Pennsylvania. The Texas AG said the rule is unconstitutional. Vermont adopted the rule in its entirety. And depending how you count, New Hampshire and Maine may have adopted it, but I think their rules are a little more narrow. So either 2 or 3 states have adopted it, and I can be persuaded other ways how you count it. All right, I want to convey to you today 4 points about this rule. The first point concerns this phrase, conduct related to the practice of law for speech that can be deemed harassment. This is a very open-ended standard. Under this standard, lectures given at CELI events, continuing education credits, or dinner time conversations at a bar function could be subject to discipline. if a speaker knows, or reasonably should know, that someone could find it derogatory. I worry that this threat of sanction will chill speech on matters of public concern. The rules and the comments don't express any awareness of this novel intrusion into the private spheres of an attorney's life. Second, I want to compare the operation of Rule 8.4G with previous ABA rules, as well as state anti-bias regimes. Now, to be clear, my concern here isn't about anti-bias regimes. I think they can be done properly. The problem is that this rule goes beyond merely policing bias, but it imposes discipline on conduct merely related to the practice of law, with only the most tenuous connection to the representation of clients, a lawyer's fitness, or the administration of justice. Third, I want to discuss 8.4G's chilling effect. Courts have generally upheld regulation of attorney speech in the context of the practice of law. But when that expression becomes more attenuated from the Bar Association's traditional purposes, the state interest becomes far less compelling. In this sense, past precedents are not very helpful. Rule 8.4G sweeps in the vast amounts of speech on matters of public concern and poses a form of viewpoint discrimination. At bottom, defenders of 8.4G can tell us to trust the Disciplinary Commission. The First Amendment demands more. We don't trust in the First Amendment context. Finally, if I have time, which I probably won't, I'll give a state-by-state overview of 8.4G. So let me start off at the outset. I think the drafters of 8.4G were well-intentioned. Sexual harassment is a problem in the legal profession. I don't want to discount that, and I'm actually quite concerned about it. During the drafting process, a number of attorneys, especially female attorneys, spoke up and said that they were being harassed after hours. They were being harassed in a dinner following a deposition, or they're being sexually harassed at a hotel if they were out of town for a trial, or they're being harassed in, say, a limousine after they had a court hearing, right? This conduct goes on, and I don't mean to trivialize that. My point is actually a little bit different. That sort of conduct can be targeted more precisely without using the sweeping language that 8.4G entertains. Right? Why? The rule isn't limited to what you might call sexual harassment, which involves what's called severe or pervasive conduct in the workforce. That is something that we know, more or less, how to prohibit. It refers to harassment more general, which need not take any sort of sexual aspect. Indeed, the comment defines harassment as demeaning or derogatory speech. And you can go through the dictionary definitions. Demeaning or derogatory is a very open-ended phrase. It could basically just mean something you find offensive. And there are large portions of the law that when you and I speak about, someone may find demeaning or derogatory. This rule also extends not just to conduct in the practice of law, but conduct related to the practice of law. And it specifically enumerates bar functions, CLE events. This event right here, I think, could be deemed conduct related to the practice of law. You all need to go to law school to become an attorney. You're here. This is part of your curriculum, part of your exposure. If any of you are unhappy with what I said, and you found that I said something demeaning, which you might, you can send a letter to the bar. Now, I'm tenured, thankfully. I'm not going to get fired, but I'm going to have to deal with a bar complaint. And those are not fun to deal with. Okay? And now let me give you a couple examples, right? So the rule proposes 11 different grounds of discrimination. Let's start with race. Let's say we have a debate on affirmative action. And let's say a speaker says, affirmative action should be banned because it hurts minority students. It places them in a position where they have a lower chance of success. Now you may think that's an insane position, but it's a view that's somewhat widely held. And several of the members of the Supreme Court probably hold that view. That view can be seen as being derogatory or demeaning on the basis of race, and that can give rise to a bar complaint. Another speaker says in a debate, women should not be eligible for combat duty. Again, that's a position that I think is probably widely held, but can be deemed demeaning on the basis of race. Disability. Someone says people with mental handicap should be eligible for the death penalty. That's a contestable position, a public concern that the Supreme Court argues with every couple of years, but it's one that I think could give rise to a bar complaint. Someone could say something at Title IX and transgender access to bathrooms. again, this is before the court now, basically this term. But it could be deemed demeaning to trans people on the basis of this rule. And I can go on and on and on. For each of these topics, which I chose for deliberate provocativeness, a speaker could know or reasonably know that someone might find the event a remark disparaging based on one of the 11 protected classes, right? Now, if you think that these accusations are frivolous, the Supreme Court says stuff, right? Justice Scalia made arguments about what's called mismatch theory, that affirmative action harms minorities, and he was castigated for it. He was attacked for it. So you can imagine people who want to use this rule for bad ends can just file bar complaints. I don't know if it will happen, but it might happen. And to be frank, I don't think this is limited to bar functions. This can even apply to social media. If I'm an attorney and I maintain a Facebook or a Twitter page for my firm, I think those tweets, those Facebook posts could be within the auspices of this rule because it's related to my practice. And now idiotic tweets can become the basis of bar complaints, merely because someone finds them demeaning or offensive. I'll make this point a little bit more broadly. More often than not, the type of speech that's demeaning is a speech on the right of the political aisle. Now, I don't want to make comments on why that is, but you can see how this rule can be targeting conservatives in particular, which is why conservatives are so opposed to this rule. Let me make the point a little more bluntly. The comment to the rule actually has a carve-out. And the carve-out says, speech designed to promote diversity in the legal profession is exempt from this rule. In other words, if a firm wants to have an affirmative action policy or some sort of diversity training that uses race in what you might call an affirmative fashion, affirmative action, that sort of conduct is not covered by the rule. This is a straight-up viewpoint discrimination. You're picking a debate and saying one side you can have a position with respect to race, the other side you can't. If nothing else, this rule should be cut out. This comment should be cut out. It's a straight-up viewpoint discrimination. This one, I'm fairly confident that the court would kill it on those grounds. Whether it's severable or not, I don't know. But this one is straight-up viewpoint discrimination. Now, I've raised all these various First Amendment arguments. The actual rule itself makes no reference to the First Amendment. No reference to the First Amendment. Doesn't even acknowledge it. I think because the drafters were afraid that if they put in some language of free speech, it would water down the rule too much. Indeed, earlier drafts of the rule had language about the First Amendment, and it was cut out to avoid being watered down. They didn't want to water it down. I think it's no surprise that we've had so much opposition to this in the state courts, because ultimately the state courts have to enforce this, and they don't want to have to deal with the First Amendment challenge. Imagine litigating a case for 6 years on a bar complaint, and the Supreme Court says this rule is unconstitutional. I don't think the states want to deal with this. They have enough. Look, there's enough bad conduct in the law to not have this problem. Clients stealing money from their lawyers, right? Clients cheating on lawyers cheating on their clients, lying to courts. There's so much misconduct in the law that I don't think the courts want to deal with any of this. Okay. Now let me move to the second part of my talk. There were anti-bias provisions before 8.4G. In fact, I think there are lots of aspects of the model rules that can already police anti-bias. But the states that targeted, for example, gender identity discrimination and sexual orientation discrimination or sexual harassment made the rule more precise. Or to use the language of the law, these rules are more narrowly tailored, right? When we're dealing with speech, we can't just have these broad prophylactic policies. We have to have a targeted policy to narrowly address some problem, an interest of the highest state order, we call compelling interest perhaps, right? And the states have done this, limited the scope of the rules to conduct in the practice of law, conduct in the practice of in the managing of a legal firm. These sorts of language was used to ensure that attorneys maintained a private sphere, right? When you sit for the bar, you don't become a public official in the same way that an elected office would, right? I don't think what I'm saying now would apply to judges. Judges have their own ethics codes. There might be some First Amendment problems there as well, but I don't think what I'm saying now applies to elected or appointed officials. Private attorneys are members of the bar, but they're still private citizens, and their private sphere should not be dragged in this fashion. I think at a minimum, the conduct must be related to the delivery of legal services, right? These conduct related to the practice of law outside goes a little bit too far. And there's actually a state common law angle here as well. State bars are entities of limited jurisdiction. The states give them certain power to regulate activity. They can't regulate whatever they want. I think a lot of these rules can be ultra-virus, that the state courts don't have the power to go after private conduct. So there are also state challenges as well. Now let me move on to the First Amendment. The Supreme Court has had, Mr. Ty will concur, a very disjointed First Amendment jurisprudence. Is that a fair statement?
Yeah.
I think that's right.
I think it's a kind statement.
It's a kind statement. It's messed up, right? And I'm talking about what might be called the commercial speech doctrine, which you may have studied in your First Amendment classes. At various points in the 70s and the 80s and the 90s, the court has hinted that certain types of commercial speech is not treated in the same fashion that a political speech might be treated. If you have advertisements for pharmaceutical products, right? Or if you have advertisements for like public utilities, a couple of the more prominent examples, the state might have more latitude to regulate that speech, to prevent misinformation, to reduce the risk of fraud, to ensure people have accurate knowledge about medical products, etc. So what we might call strict scrutiny historically has not applied to this chunk of speech called commercial speech. I don't know if that jurisprudence is staying where it is. In recent years, the court has become much more willing to closely scrutinize restrictions of speech, even where commerce is involved. And I want to talk about a recent case decided a couple years ago called NIFLA versus Becerra, the National Institute of Family and Life Advocates versus Becerra. This is a case out of California. And in this case, you had what are called crisis pregnancy centers. These are centers that don't provide abortions. They try to indeed discourage people from obtaining abortions. And they give them information about adoption and some other things. They do not want to give information about where the nearest Planned Parenthood clinic is. That's not their mission. And the state of California passed a series of laws that required these facilities, which may or may not be staffed by doctors, to give information about where to obtain abortions and potential public funding for abortions from the state. California argued this is a regulation of professional speech. You have both licensed and unlicensed medical facilities, and we're just telling them what kind of documents to display. And there's some history of this. If you read the Casey decision, which is in the news now, part of the Casey decision was requiring doctors to show pregnant women disclosures about what they're getting into, so-called informed disclosures. So there's some history of the state requiring medical professionals to show information. The court ruled against California here. And the court made a lot of, I think, broad sweeping pronouncements. This was a Kennedy opinion as well. It was a Thomas opinion, but Kennedy joined it. So first off, the court says that there is no professional speech exception to the First Amendment. Right? The mere fact that speech regulations exist for license holders, that doesn't mean you're outside the scope of the First Amendment. Right? The First Amendment restricts certain licensing requirements. And what are examples of so-called professional speech? The court mentions doctors, nurses, physical therapists, truck drivers, bartenders, barbers, and lawyers. And I don't think that was inadvertent. That was put in that list, I think, quite deliberately. I think the court was signaling that a lot of these restrictions on attorney speech now comes within the ambit of the First Amendment. Lawyers are in that category. The court says the government lacks an unfettered power to regulate the speech of lawyers merely because they provide professional services after receiving a professional license. There's some older decisions, one called Zauderer versus Office of Disciplinary Conduct of the Supreme Court of Ohio, and that refers to disclosing fees and things regarding how much you're charging, right? The court said, fine, maybe we can regulate those old things, but they really cast down that precedent as well. And this rule applies not just to words, but also conduct, right? Conduct and things you can do in the legal practice. I read these precedents to say that 8.4G will be reviewed, if not with strict scrutiny, something approaching strict scrutiny. And if you require this sort of narrow targeting, then this law is on very shaky grounds, precisely because it's not surgically defined. It sweeps in a broad range of conduct that has little to do with the practice of law. Now, I have a proposal, which I can maybe read you later, of how I would revise 8.4G. I think you could. I think if you narrow the scope to legal practice, then this might pass muster. There's some other things, socioeconomic is a little trickier because it's, if I say I don't want to hire any rich people, I want to help the poor, I only want to help disadvantaged students, you are discriminating the basis of socioeconomic status. It's kind of like the reverse Bernie Sanders thing, right? You can't do that because it's got to be a two-way street. So I think you can chop this rule up a little bit, but at a basic level, its current status, I think, is unsustainable. It has been adopted in 1, 2, or 3 states, depending how you count it. There's been no litigation. I understand some of the bar members in New Hampshire have sought what's called an advisory opinion from the state courts, asking for input on whether the rule is permissible, but I'm skeptical that they'll give anything meaningful. All right, I think my time is up. Professor Tepker, and take some questions from you later. Thank you all so much. Boy, there's left and right podium. This is perfect. We're talking about the presidential debate. I will call you names, I promise.
Okay. Same here. Thank you for having me, and I really appreciate the Federalist Society willingness to listen to somebody of ultimate bias and leftist domination. I understand I was designated as having that. I thought, since I might be misunderstood, I might say a few words about my background, which I generally haven't advertised, not out of shame, but I was also technically an attorney for Charlton Heston and Ronald Reagan. And this meant that I was a member of a big law firm. They were clients of the firm, therefore all the attorneys are clients of the firm. But I actually did work for Mr. Heston and the LA Convention Center and the Los Angeles Times. But my primary work was in that very leftist activity of busting unions, saying to unions, you ought to follow your contractual duties. You shouldn't strike in breach of collective bargaining agreements. Since becoming a professor, my one primary digression away from the teaching of law is when I'm serving at the United States Equal Employment Opportunity Commission, appointed by that notorious leftist biased individual, Clarence Thomas. And I did work on a team of lawyers on the field of academic freedom in reference to claims of the EEOC. I was on the EEOC team led by Kenneth W. Starr. I point this all out not to claim that I am a movement conservative, but my conservative credentials are probably much easier to recite, at least in a short time frame at the beginning of a speech, than my leftist-dominated bias. I'm here for respect for free speech, but also for the general direction of making bar associations more responsive to public concerns about equality of opportunity. I support the general movement in the direction established by proposed Model Rule 8.4G, but that doesn't mean I favor every tale and word of the proposal. But I want to defend the essence of it. The remarks of my honorable, distinguished colleague illustrate the tone of opposition. And the opposition has been enormous. He counts it up. There haven't been many communities that have decided to accept it. I don't expect there will be. But I do think more and more states are going to do more and more to deal with this issue. Now let me return back to the language and try to explain what it is I would defend. The idea that it is professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, etc., etc. The key word here is conduct. A second key word is discrimination. A third key word is harassment. This first sentence excludes most of the very imaginative, creative explanations about the possible implications of adopting this rule. All of which, in my view, would be wrong interpretations of the rule, wrong to do to the attorneys. I only wish Drew would record his laugh and light things up. Drew has
I'm getting a phone call from the accounting services in the United Kingdom.
So that won't get you laughing, I know that. Drew has one of the best laughs the world has ever known. We hope to patent it someday and market it. So far, I haven't cracked a joke enough to actually bring it to bear. Okay, I give up. I suggest to you one basic conclusion. The rule as written is not substantially overbroad. Even Josh used the phrase a little overbroad at one point in his speech. A little overbroad won't get you a facial attack by a federal court. It has to be substantially overbroad. Now, how do we assess that? I think the best, most recent opinion on the subject comes from that noted leftist, Justice Scalia, who said that the real key is whether the core provision of a modified 8.4G, does it purport to cover, regulate, discipline any protected expression or conduct? And I suggest it does not. It is not enough to prove somebody said something in a political talk that somebody thought was derogatory. That's not proof of discrimination. And I would defend them in any court against application of this rule. When the Texas AG cites examples and other critics, Edwin Meese says it's close to fascism, which I think was a silly thing to say. One of the examples they come up with is something very much like the example you provided. If a lawyer stood up at a conference and said Blue Lives Matter, he could be disciplined. Nonsense. There is a clear First Amendment argument to be made. At best, the prophecy that the person would be disciplined rests on the idea that the judges will ignore the First Amendment and misinterpret 8.4G. But addressing a matter of public concern in a way that's controversial is still protected in this society, and it still ought to be. But that idea shouldn't immunize lawyers from direct personal insults at colleagues, minimizing them with sexist or racist comments. It shouldn't protect against a lawyer abusing a client, offering him a torrent of either racial or gender abuse. It shouldn't prevent sexual harassment. Now, I understand much of the argument Professor Blackman has made gains force from well-known criticisms of sexual harassment rules. I understand that. I had enough examples when I was defending employers in Los Angeles. That was my primary work, defending employers against discrimination lawsuits. So I understand how it can be done, how it needs to be done sometimes. Discrimination laws frequently involve words that are ambiguous, sometimes overbroad, but not so much that they get struck down as fatal or wrong-headed unless they're substantially overbroad. And on the issue of sexual harassment, I would just remind you that there are two principal cases, both of which are unanimous, one of which was written by that noted leftist, Antoinette Scalia, in favor of sexual harassment guidelines and application of it as improper conduct. The idea that might be made a measurement of whether a lawyer is doing their job and upholding their professional obligations is hardly revolutionary. Likewise, even when applied to religion or race or some of the other subjects, I think it's something we need to work toward. Now let me say, I'm not in favor at all of what I believe you use the term an anti-bias approach. Bias is too broad a concept. Anti-bias often connotes a measure of thought control, which I oppose and will continue to oppose. This rule has to be tied carefully, narrowly, effectively to conduct, to disparate treatment against human beings on the basis of improper characteristics. There's nothing in this rule which prevents interpretations, care, skill in trying to change the legal profession. One of my favorite quotations comes from Lincoln, as I'm sure my students are nauseated to remember. Accustomed to trample on the rights of others, you've lost the genius of your own independence and become fit subjects for tyrants among you. I suggest to you that we've had too many people in our profession who've been tyrants, bigots. More needs to be done. This is an attempt to do it. It is actually an attempt using language, and I can go through more of Justice Scalia's very effective Virginia v. Black analysis of substantial overbreadth to make that point effectively. This is something that needs to be done, and I hope progress will be made in communities that are plainly resisting this kind of choice. Thank you very much.
Thank you. Thank you. I have only one brief response. If this rule is limited to conduct, I would withdraw most of my objections. But comment 3 defines harassment to include derogatory or demeaning verbal conduct. It's not just acts, it's verbal conduct, which means words. So to the extent the rule applies to verbal conduct, that means words, we are in the realm of speech. I wish also that this rule was bound by Justice Scalia's wisdom, but it's not. The rule says that you may find support in the various anti-discrimination regimes, and it's not bound by any one ruling. So it's not governed by it. So for example, a sexual harassment law, you have a requirement for what's called severe pervasive conduct. If that was in there, I think I would withdraw a lot of my objections if it actually modeled federal discrimination law, but it's not. A single comment could give the basis for liability. That's all I want to say.
Let me just we'll get to your question in just a second, Joe, but it does speak about using Title VII standards and other legal standards for harassment. The definition of harassment requires severe and pervasive actions. It may include verbal conduct, but that verbal conduct has to be of a sexual nature and it has to be severe and pervasive enough to create an intimidating, hostile work environment. Those are high standards. They're not low standards.
I agree.
And that is the most controversial element of the sexual harassment rules. I just don't think we should continue to have a profession which insists on handling cases which impose sexual harassment rules and duties on the rest of the citizenry, but pretending they are exempt from them. These issues of definition and enforcement can be worked out.
Okay. Next one, questions.
So
Professor Ty, please.
Yeah, I just want to be the peacemaker. First, thanks to both of you for offering your learned and passionate perspectives.
There's no war.
I don't see. Well, that's my peacemaking comment, which is I don't see a lot of First Amendment daylight between the two of you. It seems like the flashpoint really is how to interpret the model rule, right? And it seems that your position turns in part on the commentary. And so my question really is, Professor Black, to what extent is the commentary binding? I mean, if states don't adopt the commentary, would the reading of the rule potentially be closer to what Professor Tepker says?
I think we have a lot of similarity. We agree on another point. I think a facial challenge would fail. I think you're exactly right. With facial challenges, you have to show what's called substantial overbreadth. I don't think you meet that threshold. So basically what you're left with is an as-applied challenge. It is the bar brings some disciplinary action against a citizen, right? The bar brings a disciplinary action against a citizen, and at that point you have to defend himself. Now, my concern is, I don't think you should have to defend yourself against a vague rule. My strong preference, right? My strong preference is to not adopt rules and give rise to litigation. In other words, I don't want to work things out. I'd rather get a clean rule at the outset than have someone's life, liberty, and either profession on the hook, waiting for some court in 6 years to decide what this rule means. I'd rather have a clear rule at the outset rather than leave it to the courts to figure out.
I'd like to just respond directly to Professor Tai's question. Your question is, how authoritative are the comments? If I
didn't answer that part of the question.
Oh, that's all right.
The answer is in most states. I'm answering this because I taught professional responsibility for almost 40 years. The answer is that in most states they adopt only the what I'll call the statutory language itself, what we all call black letter. The comments are interpretive, are a place to look for interpretations, but they're not. Very few states adopt the comments as a kind of a binding interpretation. So the answer is they're authoritative in the sense of that it's like the UCC. You read the UCC and you read the provision about Article 9 security, and the comments are very helpful to understand it, but they're not binding, and they're helpful, but don't have that authoritative level. So the comments are important, and I certainly would pay attention to them. I'll often look at them, but a court's not really going to say I'm sort of bound by them.
I also like to say I very much like what Professor Blackman has said about areas of agreement. If the tone of some of the criticisms elsewhere were just a little bit toned down and dialed back, we might make some progress in making an overall better rule. For example, when the First Liberty Institute, with Edwin Meese signing off on the letter, described this as close to fascism, that's over the top. It's hard to put your finger on it. It's too general to really refute it. And I must confess, I certainly have seen occasions where so-called anti-bias activity is very bothersome to me. And I won't say anything more right now about that, but I don't think this is the case for that being made. This rule, as written in the definitive operational language, is limited to conduct. Now, the speech conduct distinction can be misleading. I don't want to place too much faith in that. But I do believe that this is designed to address non-expressive elements of behavior. Treating people differently. Treating people differently based upon standards defined by other public policy and law that is known, should be known as a violation of equality. I would urge studying this issue with that restrained objective in mind.
So my first question is for Professor Blackman. So Black.
What is it?
Blackman.
He said Blackman.
That's my name.
Yeah.
Oh, what is it?
You said Black. I don't want to correct you.
Yeah. Oh. Wait a second.
Blackman.
Have I gotten your name wrong the whole time?
That might be right. It's okay.
I got scared now that I got it wrong.
No, the student got it. Professor's wrong.
Good. So one of in a couple of your articles that you've written, as well as what you've discussed today, it feels like one of the problems you have with 8.4G is definitely what you feel is its overbreadth. Mm-hmm. But in comment 3, it describes that the substantive law of anti-discrimination, anti-harassment statutes and case laws may guide application of paragraph G. That feels like it's inherently the ABA giving it a limiting function using those laws. Does that take care of some of your concerns that you would have with it?
Smooth. That was actually very good. You didn't freak out. That's good. I think my objection there is the may guide. May guide. If they put the word severe pervasive in the comment, I would withdraw a lot of my objections. The may guide is quite nebulous. And I think what Professor Tepker's arguing is that in our profession, we shouldn't have the sort of high barriers of the severe and pervasive requirement. If you read the drafting history, I think they watered it down, no pun intended, to avoid these sort of stringent requirements. So I think if push comes to shove, Title VII will not be the lodestar. I think it will be a more fluid basis, which would basically make it easier to find bar liability than you would have to go through the EEOC process. So the may guide language bothers me. I would stick the severe and pervasive one right in the comment.
I would favor retention of severe and pervasive for the application of sexual harassment guidelines. I do think there are some additional standards from the Constitution and other statutes which ought to be considered. But to answer your question more specifically, looking at other laws is the beginning of an appropriate analysis that ought to guide judges, courts, and administrative agencies in the application of the rule, and I hope they follow that. If they don't, there will be problems. But I don't think you should oppose a policy because it might be misinterpreted, or oppose a proposal because it might turn into something else. I think the more rigorous standards used for substantial overbreadth, as defined by Justice Scalia and Virginia v. Black, are a better guideline for us when evaluating that.
Thank you.
Professor Tepker, could you comment just briefly on the part of the rule that Professor Blackman
Not yet.
read about the rule?
Let the record show the prediction has been made.
Lord help you all. One Justice Blackman's enough.
The language of the rule that applies the body to conduct that is related to the practice of law, and how that may be subjected to abuse beyond the author's intent.
Well, I do agree that there might be some occasions where sexual harassment might occur in a private setting. The pattern of cases is that's more difficult cause of action to establish under Title VII. Conduct at the workplace is more easily defined as a violation. I also have to say that I'm not at all persuaded by any of the examples of conferences. I don't believe this is going to be used as a bludgeon to attack critics of affirmative action or to attack critics of various aspects of civil rights law. I do believe that what they're really after, or they should be after, I should say, are direct personal insults, mistreatment, abuse that amounts to disparate treatment, discriminatory conduct. I'm not at all willing to say that the basic principles of anti-discrimination law, which I taught for almost 40 years, can be easily transported into a code of censorship. I don't believe that is likely. I don't believe it is probable, and I certainly don't think it's desirable. But that's the threat that has often been made by the critics. They're transforming the proposed model rule change into something I don't think it's intended to be.
Would you be willing to support amendment to the rule to more narrowly attack that kind of
Yes.
conduct that you just mentioned?
Yes.
Okay. Maybe one more question.
Yeah, I guess I have another one that
Yeah,
I
go for it.
So this one is going to be more directed towards Professor Tepker. So since this model rule was adopted by the ABA back in 2016, there has been, I think, what could be fairly said, a reluctance for states, regardless of how you may feel about like political lean of the states, or regardless, to accept the rule as stated by the ABA. Do you think that signifies an inherent weakness in the rule, or do you think there's some other reason behind this seeming reluctance of acceptance by state bar associations?
Well, on this point I have to confess to some cynicism. Lawyers tend to be very influential in their communities, and they have a great deal of influence in resisting regulation. I'm I'm not at all surprised that they're effective in stopping measures that be unpopular. Now, to what extent it's unpopular because of knowledge of the rule or misplaced worries of the rule requires data I do not have. I think the attacks on the rule have been widespread, vehement. I think in many ways they've misrepresented what the rule has done. So far it's been effective. I do think that if the rule is to be adopted, or something like it, it will require some measure of change. The core principle is holding lawyers to account for violation of the principle that they should not engage in discriminatory conduct or conduct amounting to harassment. Whether you use comment 3 or some other formulation of words, that's the principle, the core principle I want to defend.
All right. Briefly.
This is off topic, but since we're talking about ethics and the Supreme Court, should they have a code of conduct for themselves?
Okay. I'll answer that one, then we'll wrap it. Then we have a hard stop coming up.
I won't.
I think constitutionally Congress could. Chief Justice Roberts has sort of hinted that Article 3 creates the Supreme Court. Yeah, it creates the court, but not the justices. Those are created by statute. So I think the judges of the Supreme Court could be bound by an ethics code. Should they? Yes, but the recusal rules might feel a little different. Because if you have an easy way to recuse a justice, I think people will try and get them recused very quickly. And there are only 9 of them. You can't like pick from a bench and draw another one. So I don't know what it will look like, but I think constitutionally it can be done. Very good. Thank you all so much.